If you got a question, feel free to give us a call, 392-1544. You can always email us at lawcall@wmbb.com. Ted, let's jump right in tonight with our first email question. And here, if they'll put it up on the screen, there we go. Someone hit me and I kept going, or someone hit me and they kept going.
No, this is a different one right
Okay,
here.
well, here's another one. All right, drywall from Alan. I was on a drywall side job under no company or workers' comp. The ceiling collapsed on me and my friend. Had hospitalization and multiple areas of stitches. Who was responsible? The one who hired us or the property owner? All right, Ted.
Alan, that's a tough one right there, buddy. I'm sorry you're dealing with that. The way it goes in Florida law, with respect to what you're dealing with here, is what's called a premises liability situation. And it doesn't necessarily boil down to who was the owner of the property. It's more importantly characterized as who was in control and had the right to control the premises. So there's a lot of questions we still need to answer there to know who had that right to control that property. And then just because there was an accident and that the ceiling caved in on you does not mean that there's liability just because that. The fact that you were injured and something happened, we need to establish and prove that there was negligence, which means there had to be the failure to use reasonable care under the circumstances. So was this a situation where you're dealing with more or less a condemned building that should have been properly stabilized before you got in there and worked? Was it a safe working condition? Those kind of situations, if you're dealing with that, the liability is tending more likely towards the person who hired you, because that person should have taken care of that and made sure that was done before they allowed you to enter and do that work. And a lot of times when you're dealing with an owner-contractor situation, if the owner is truly hiring an independent contractor to do the work, a lot of times it's going to be difficult to hold them liable.
Right.
But however, if they overstep that boundary and are very diligent in activating and telling how you do the work and taking control and more or less acting like a general contractor or manager, they can pull themselves into liability. So it's important when you're in that role to make sure you keep that distance and let the people do their jobs.
Well, Ted, also, if an employer or a contractor does not carry workers' comp insurance, and they're supposed to and they refuse to, explain the difference in Florida law about that, because if you have workers' comp, you have immunity under that statute.
Yes, there's a quid pro quo in the workers' comp system where if you properly have the requirements and meet the statutes, then you are not allowed to be sued in tort. So you cannot get some things that we normally would get, such as pain and suffering and different mental anguish. A lot of the non-economic damages are not going to be allowed in the workers' comp system. It's basically you get your medical bills paid, and if you miss work, you get your time off on that as well. But if the employer is required to and fails to carry comp, then you can sue them in tort, and or you also have the option to pursue the statutory remedies on the comp. Typically, you're going to be better off to go after them under tort at that point in time. We've had several cases where that has been the case. And it's something that you got to explore and you got to look at. You always want to look at what are all the options so that you have the information so that you can make an educated decision on what you should do. And in a situation like this, there's going to be some issues first where you have liability, and then you got to find an avenue that actually gives you a practical recovery, because just because you have a claim, if you don't have a real remedy where you have an ability to collect, then it could end up being a Pyrrhic victory.
Right. Now, Ted, one of the biggest things about workers' comp, and that's going to lead into our next question, is if you've been injured on the job and you find yourself as an employee, make sure you file your claim. Make sure you notify your supervisor. Make sure you
quickly
whomever you got to go get to notify that there was an injury that occurred, an accident occurred, because that's paramount to establishing basically the foundation of an incident.
Absolutely, and you want to get it documented. If they kind of give you the runaround, make sure you want to talk to whoever's in the HR. Make sure you're getting that, and if you keep getting the runaround, make sure you ask to speak to the owner directly. Do it, and if you keep and you're not getting any response, make sure you put it in writing. You need to document this thing. But even if you do have a situation that falls under the purely normal comp situation, you're hurt on the job, we have it all the time, there still may be a tort recovery there. Because, for example, if I'm a FedEx driver or someone and I'm driving and someone hits me, I was on the job, so I have a workers' comp claim, but the person that hit me is not off the hook. That is a third party that is not your employer, and if you can establish that they failed to use reasonable care and caused the accident, then you have a third party claim against that driver. So you need to explore it so that you know what your options are, so that you can make the best decision for yourself and your family.